Imagine a client walking into your office. They've been with their partner for 18 years. They share a home, raise 4 children, and made vows in a sincere religious ceremony. Now the relationship is over. Naturally, this client assumes their long-term commitment and those vows guarantee them legal protection and a fair division of the assets they built together. But under the law of England and Wales, the duration of a relationship and the depth of emotional commitment are legally irrelevant. Living together for 2 decades does not give the court any power to divide property. Powerful financial remedies like property transfers, pension sharing, and spousal maintenance are only available if the relationship triggers the court's statutory jurisdiction under the Matrimonial Causes Act 1973. If they cannot access the 1973 Act, the court treats them as mere cohabitants. They are subjected to strict, unforgiving property and trust principles, where one party can walk away with everything held in their sole name. This means the mandatory first step for any family law practitioner is not looking at how the couple lived, but verifying the strict, formal validity of how the adult relationship was legally formed. Intention and commitment offer no shelter. If the structural formation of the marriage fails to meet the requirements of the 1949 Act, the client is entirely unprotected. This tree outlines the Marriage Act 1949, showing pathways to formal validity. Church of England, Jewish, and Quaker weddings have exemptions regarding civil preliminaries. But look at this separate branch for other religious ceremonies, like in Islamic nikah or Hindu mandap. For these faiths, the religious ceremony itself is not enough to create a marriage. The event must map entirely onto strict civil requirements to be legally recognized by the state. 3 civil hurdles are mandatory. The couple must give formal notice at a district registry office. The ceremony must take place in a registered meeting place for religious worship, and a civil registrar or authorized person must be present. When couples undergo a religious ceremony without checking these civil boxes, a critical legal problem emerges. We have to determine the consequences in English law when these civil formalities are bypassed or executed poorly. For non-exempt faiths, religious compliance is completely distinct from legal compliance, and only legal compliance provides access to family court remedies. Failure to comply with the Marriage Act doesn't result in a simple outcome. We must look at a spectrum of validity. On the far right is a valid marriage. If there are defects, it doesn't immediately vanish. Instead, it is classified as a void marriage. Under Section 11, a void marriage has defects but resembles a marriage enough to grant court jurisdiction. If void, you can obtain a decree of nullity, dividing assets like a divorce. But then we reach the spectrum's far left, the non-qualifying ceremony. Also known as a non-marriage, this formation attempt is so flawed it is meaningless in English law. Because it's not a legally recognized marriage attempt, no decree of nullity is possible. That means zero access to financial remedies. The critical legal distinction lies at the boundary between a void marriage and a non-qualifying ceremony. This threshold determines if a client receives family court protection. How does a court decide if a ceremony is close enough to civil law to be deemed void? Consider the 2013 case, Assad versus Kurder. The couple had a Syriac Orthodox church ceremony before moving. The ceremony missed key procedural marks. The couple entirely failed the requirements of giving prior notice and obtaining post-ceremony registration. However, the judge reasoned the attendees understood it as a marriage ceremony. It bore enough hallmarks of an ordinary attempt to form a legal marriage. The judge ruled the ceremony was not so deficient. Classified as void, it allowed financial claims. A genuine, recognizable attempt to form a marriage, even if procedurally defective, can preserve the financially weaker party's right to statutory relief. The outcome changes drastically when there is a wholesale failure to engage with English formal requirements. In the 2011 case of El Gamal versus Al Maktoum, a secret Islamic ceremony occurred in a London flat. Due to a total absence of civil compliance, the court dismissed the nullity application entirely. This boundary was definitively cemented by the Court of Appeal in the landmark 2020 ruling, Akhtar versus Khan. The facts were compelling: an 18-year relationship, raising 4 children, and a sincere nikah ceremony. They treated it as a marriage for tax and social purposes. Despite the emotional weight, The statutory reality was unyielding. The couple gave no notice to a registrar, the building was unregistered, and no civil registrar was present. The Court of Appeal ruled the ceremony did not even qualify as a void marriage under Section 11 of the Matrimonial Causes Act. As a non-qualifying ceremony, the wife was barred from seeking nullity, completely denying her financial remedies. The practical fallout of the Octor decision is severe for the financially weaker party in an unregistered religious ceremony. Without the Matrimonial Causes Act, the court cannot transfer property to achieve fairness, it cannot order spousal maintenance, and it cannot split a pension. The law treats these clients as legally identical to cohabitants who never underwent any ceremony at all. Establishing ownership of the family home in these cases will rely entirely on complex, rigid implied trust principles, like resulting or constructive trusts, which prioritize direct financial contributions over family needs. Failing to satisfy civil preliminaries strips away intended financial partnership, leaving family courts powerless to intervene equitably. When faced with a client who had a non-traditional ceremony, family law practitioners must follow a strict intake protocol. Determining formal validity is the critical first step. You must investigate the exact location, the authority of the officiant, and track down the civil paperwork from the ceremony. Never accept a client's assertion of marriage at face value without documentary evidence of civil compliance. Personal intention and religious sincerity cannot override a wholesale failure to comply with the Marriage Act 1949. Mastering the rigid threshold between a void marriage and a non-qualifying ceremony is the essential foundation for advising any client on their true legal standing. It ensures they understand whether the law will protect their financial future or leave them to stand alone.